Supreme Court issued unprecedented 9-0 unanimous decision. May 28, 2026, fundamentally changing relationship between Second Amendment gun rights and Fourth Amendment search protections. Court just held. Police cannot search your person, vehicle, or belongings based solely on lawful firearm possession. Cannot extend traffic stops to investigate firearms when you're legally carrying. Cannot disarm you without reasonable suspicion you've committed crime, and cannot use presence of legal firearm as justification for warrantless searches that would otherwise violate Fourth Amendment. In landmark case Miller v. Pennsylvania, all 9 justices agreed that when citizen lawfully possesses firearm under Second Amendment, that constitutional exercise cannot be treated as suspicious activity justifying Fourth Amendment intrusion. Justice Gorsuch, writing for unanimous court. The right to keep and bear arms would be meaningless if its exercise provided government with automatic justification to search the person exercising it. When citizen lawfully carries firearm in state permitting such carry, that lawful conduct cannot be bootstrapped for search any more than attending church could justify search. Constitutional rights do not trigger constitutional violations. Subscribe, because understanding this 9-0 decision affecting both gun rights and search protections, why every justice agreed, what police can no longer do during traffic stops, and how this changes enforcement nationwide determines whether you protect yourself from illegal searches. James Miller, Pennsylvania resident with valid concealed carry permit, was pulled over for broken taillight. During stop, Miller informed officer he had firearm in glove box as required by duty to inform law. Officer immediately ordered Miller out of vehicle, handcuffed him, placed him in patrol car, and searched entire vehicle without consent or warrant. Officer claimed lawful firearm possession created officer safety justification. Search uncovered nothing illegal. Miller sued under Section 1983 for Fourth Amendment violation. District Court dismissed, qualified immunity. Third Circuit affirmed. Supreme Court reversed 9-0. Holding lawful firearm possession cannot justify warrantless search. Let me break down what court held, why all 9 justices agreed, what police can no longer do, how this affects traffic stops, and what gun owners should know. Number 1. What Supreme Court held unanimously. Core holding. When citizen lawfully possesses firearm under Second Amendment, that lawful possession cannot be used as justification for Fourth Amendment search or seizure. Police cannot search person, vehicle, or belongings based solely on presence of legal firearm. Cannot extend traffic stops to investigate lawful firearm. Cannot disarm lawfully carrying citizen without reasonable suspicion of crime beyond mere possession. Justice Gorsuch, unanimous opinion. 2 constitutional provisions collide. Second Amendment protects right to keep and bear arms. Fourth Amendment protects against unreasonable searches. Question. When citizen exercises Second Amendment right by lawfully carrying firearm, does that exercise automatically trigger Fourth Amendment search authority? No. If lawful exercise of constitutional right provided justification for search, government could search anyone attending church. First Amendment, anyone declining to answer questions. Fifth Amendment, anyone requesting attorney. Sixth Amendment. Constitutional rights would become triggers for violations. We reject this paradox. When state permits citizen to carry firearm through shall issue licensing or constitutional carry, citizens exercise as lawful conduct. Lawful conduct cannot be treated as suspicious activity. Officer safety concerns do not override Fourth Amendment. Officers routinely encounter lawfully armed citizens. 24 states have constitutional carry, millions have permits. If lawful firearm justified search, Fourth Amendment would be nullified in half the country. Absent reasonable suspicion of criminal activity beyond mere possession, officers cannot search person or vehicle, cannot extend stop, cannot disarm citizen. Why unanimous? Conservative justices, Thomas, Alito, Gorsuch, Kavanaugh, Barrett. Protecting Second Amendment exercise. Liberal justices, Sotomayor, Kagan, Jackson. Protecting Fourth Amendment from police overreach. Roberts joining, emphasizing constitutional rights protection. No dissents, no concurrences. Number 2, what police can no longer do, and nationwide impact. Cannot search vehicle based on legal firearm. Officer pulls you over for speeding. You inform officer you have firearm in center console. Officer cannot search vehicle, cannot open console, Cannot examine firearm without consent or probable cause of crime beyond possession. Cannot extend stop. Officer pulls you over for broken taillight. You inform carrying concealed with valid permit. Officer cannot extend stop to run serial numbers. Check permit beyond police database. Question about firearm beyond confirming it's secure. Rodriguez versus United States, 2015. Stops cannot be extended beyond traffic mission. Miller applies this to firearms. Cannot disarm without reasonable suspicion. Officer cannot disarm you for safety. Unless officer has reasonable suspicion you committed crime. Lawful carry plus traffic violation is not reasonable suspicion. Requires articulable facts. Furtive movements toward firearm. Statements indicating unlawful intent. Warrant. Credible crime report. Cannot handcuff based on firearm. Officer cannot handcuff you, place you in patrol car, or detain beyond normal traffic stop based solely on legal firearm. Cannot demand consent using firearm. Officer cannot use legal firearm to pressure consent. You have gun, so I need to search is coercive. Constitutional carry states, 29. AK, AL, AR, AZ, FL, GA, IA, ID, IN, KS, KY, LA, ME, MS, MO, MT, NE, NH, ND, OH, OK, SC, SD, TN, TX, UT, VT, WV, WY. Police cannot treat firearm possession as suspicious. Anyone can legally carry. Shall issue states, 21, CA, CO, CT, DE, HI, IL, MD, MA, MI, MN, NV, NJ, NM, NY, NC, OR, PA, RI, VA, WA, WI. Police can verify permit but cannot search based on valid permit. Duty to inform states, 12. AK, AR, LA, MI, NC, OH, OK, PA, SC, TN, TX. Notification cannot be treated as consent to search or disarm. Number 3. Liability and what gun owners must know. Evidence suppression. If officer searches based solely on lawful firearm and finds contraband, evidence suppressed under exclusionary rule, cannot be used in prosecution. Qualified immunity eliminated. Gun owners searched based on lawful firearm can sue officers personally under Section 1983. Miller clearly establishes violation. Officers face compensatory damages, rights violation, emotional distress, punitive damages, attorney's fees. Municipal liability. Under Monell, cities/departments maintaining policies violating Miller face institutional liability. Millions in potential class action settlements. Know your rights during stops. 1. If stopped while carrying, officer, I'm informing you I'm lawfully armed with valid permit. Firearm is in location. How would you like me to proceed? 2. If officer asks to search, I do not consent to searches. Under Miller versus Pennsylvania, my lawful possession does not justify search. 3. If officer searches anyway, don't physically resist. State, I do not consent. I'm invoking my Fourth Amendment rights. Document after stop. 4. If officer disarms you, don't resist. State, under Miller, you cannot disarm me without reasonable suspicion of crime. What crime do you suspect? 5. If officer extends stop, after ticket issued, ask, am I free to go? If extended, under Rodriguez and Miller, you cannot extend this stop to investigate my lawful firearm. Am I detained or free to go? Document violations. Write detailed account. Officer name/badge, time/location. What you said, what officer said, whether you consented, what officer searched/found, whether handcuffed/detained, witnesses, request-cam/body cam footage, file complaints and lawsuits, file with Police Internal Affairs, State AG Civil Rights Division. Consult civil rights attorney about Section 1983 lawsuit. Miller establishes clearly established law, qualified immunity defeated. Educate police. Officer, Supreme Court ruled 9-0 in Miller versus Pennsylvania that lawful firearm possession cannot justify search. I'm happy to comply with traffic stop, but I don't consent to search. Bottom line, Supreme Court unanimous 9-0 decision Miller versus Pennsylvania. May 28, 2026, fundamentally changes Second and Fourth Amendment intersection. Core holding. Lawful firearm possession cannot justify Fourth Amendment search. Police cannot search person, vehicle, or belongings based solely on legal firearm. Cannot extend traffic stops to investigate lawful firearms. Cannot disarm without reasonable suspicion of crime beyond possession. Why unanimous? Conservative justices protecting Second Amendment exercise, liberal justices protecting Fourth Amendment from police overreach. Complete agreement that constitutional rights cannot trigger constitutional violations. What police cannot do: cannot search vehicle based on legal firearm, cannot extend stop to investigate firearm, cannot disarm without reasonable suspicion of crime, cannot handcuff and detain based on firearm, cannot demand consent to search using firearm as pressure. Nationwide impact. Constitutional carry states, 29. Firearm possession is routine lawful activity, not basis for search. Shall issue states, 21. Valid permit is lawful conduct protected from search. Duty to inform states, 12. Notification cannot be treated as consent to search or disarm. All departments must revise training. Evidence suppression and liability. Evidence from illegal searches suppressed. Qualified immunity eliminated. Officers face personal liability. Municipal liability for departments failing to revise training. Thousands of pending cases affected. Gun owners. No rights during stops. Don't consent to searches. Cite Miller if officer searches. Document violations. File complaints and lawsuits. Educate police about Miller. Support legislative codification. Subscribe, because this 9-0 decision protecting both Second and Fourth Amendments changes every traffic stop where lawful firearm present, and understanding your rights determines whether you prevent illegal searches. Supreme Court unanimous 9-0. Lawful gun possession cannot justify search. Know your rights during traffic stops.